sit down. Come on. Come on, buddy. Sit, buddy, sit down. Come on. Sit. No. Sit. No. Come on. All right. Come on. I need to excuse myself for a minute to get my dog up. Excuse me.
Okay.
Come on, buddy.
Okay. The 20th District Court of Travis County is now in session. The Honorable Jessica Mangrum presiding.
Good morning, everyone. Welcome to the 200th District Court. We are here in cause number 51. And let's start out with introductions of who is here and what is set for the day.
I'm Kim Kleinhans. I represent the petitioner, Deborah Jenkins, and we're here, and I believe it's the only thing set for today, which is the motion for enforcement and the alternative motion for clarification.
Okay. And Mr. Friedman, you're now representing yourself?
Today, I am representing myself. I'm represented. That is correct.
Okay. All right. And I presume, Ms. Kleinhans, there's a request for a record?
Yes, Your Honor.
Okay. And our court reporter is here and taking a record. So do we have any preliminary matters? Or are we ready to proceed?
I'm ready to proceed, Your Honor.
Okay.
I have a matter, and forgive me because I'm not aware of the procedures. I've requested a jury trial on these motions, and I'm represented by counsel, and I would like to have counsel. So I'm not sure what exactly is supposed to happen today, but as I said, I do have a jury request in on these motions, and I do desire to be represented by counsel.
Okay, Ms. Kleinhans, do you want to respond?
I mean, this isn't subject to a jury trial. It's motions. It's not the final trial. And secondarily, supposedly, per Mr. Pittman and Mr. Friedman confirmed this ever since he was served with the enforcement, which was months and months ago. He's been unrepresented and hasn't even bothered to try to attempt to get counsel as far as I'm aware of. So I think he's only trying to delay the proceedings, and I think the court should go forward in the interest of justice and the best interest of the child, given that he hasn't paid any support since the last hearing.
Okay.
May I respond?
You may.
I was served on February 2nd, I believe, is when I found the package at my door. And so that was a little over 2 weeks ago. Prior to that, Mr. Pittman had already informed me, because of his family situation, including his wife's, I think she may even be in the hospital today giving birth, but it is imminent, as well as a sensitive medical situation that he was going to need to withdraw at some point. And it is only in the last, I'd say, 2 weeks that we've agreed on that. I had not been looking for alternative counsel because I was not planning on getting alternative counsel. It was Mr. Ian's family and medical situation that required this withdrawal. So I disagree with that. And all I can say in terms of Ms. Kleinhand's comments, not being an attorney myself, is that the advice that I did receive prior to Mr. Pittman's withdrawal was that everything today would be subject to a jury trial, and that is what I would like. So I cannot say, not being a lawyer, whether Kim Kleinhans has a valid point there or not. I will say that my attorney told me that he did not, frankly, quite understand the setting for today, given the jury trial demand that went with both issues.
Okay,
Your
well,
Honor. Oh, I'm sorry.
yeah, go ahead, Ms. Kleinhans, briefly.
Yeah, I was just going to say, yeah, he's been served through his counsel, and he was counsel of record on the SAPSER and the protective order. He signed off to both of those cases with this in November 27th of 2024 when it was filed. And Mr. Pittman told me long before that he was going to withdraw, but he just took a long time to file the withdrawal. If there's been any requests for jury trial, I haven't seen it. But this is for enforcement of temporary orders.
Those were filed. I could give you the dates. I don't have them in front of me, but I surely can do that. Those were filed and accepted, I believe, 2 weeks ago.
Okay, well, Mr. Friedman, under the family code, there are certain instances in which parties are entitled to a jury trial. And an enforcement proceeding is not one of them.
That was not what I was advised by Ian Pittman, and were that the case, then I would request that this hearing be reset so that I may find counsel to represent me. I'm not prepared to represent myself in an enforcement hearing.
All right, Ms. Kleinhans, any response?
Again, that would just be an excuse to cause further delay. There's really no reason he should not be prepared, given that he said how long his counsel is not going to represent him and how long he's had since there's been notice of this proceeding, even though he was ducking personal service. His attorney of record had this since November 27th.
If I may respond to that.
And he agreed to the withdrawal. So.
Okay, briefly, Mr. Friedman.
Number one, I wasn't evading service. I was out of town for most of the month of December. Number two, and I'm not quite familiar with the vagaries here. Mr. Pittman withdrew as my counsel on the PO appeal. Of course, the PO is expired, and that was by mutual agreement. In late December, right around Christmas time, right before I went out of town, is when Ian informed me that he would need to withdraw at some point very quickly, and ended up filing that very quickly thereafter. But there was no discussion of an immediate withdrawal before that. And once again, if you're telling me that, in fact, the first thing that Mr. Pittman told me was that this would require a jury trial. So I need to be represented by counsel in an enforcement hearing. I'm not prepared to present it. It's a voluminous filing. I would also add that I have filed a motion, and obviously it's not set to be heard today because it was just filed, but I do believe it has the potential to moot this proceeding. Once again, I do want to be represented by counsel. It was not my choice to request Mr. Pittman's withdrawal, and his withdrawal was based strictly on sensitive family medical issue and the impending birth of his, I can't recall if it's another son or daughter. So that's what I have to say. I'm simply not prepared to represent myself today. And I'm not prepared to represent myself at all in an enforcement hearing. I'd be happy to represent myself in some of the motions I've been intimate in preparing, including the one I submitted this morning, potentially. But I am simply unprepared to proceed today without counsel.
Okay, well, I believe it was several months ago when Mr. Pittman first advised the court and the parties of these issues, that he was needing to withdraw or requesting to withdraw based on family medical issues related to what you have mentioned. So there is the only thing set is the enforcement. I I am going to deny the request to reset the hearing.
Well, I'm unprepared to represent myself without counsel, so all I'll be able to do today is repeat that statement every time. I'm simply, this is as you are well aware, I have over the course of the now 3 years that this has been going on, we have disproved all the original allegations. I have additional information which I filed today, which proves those allegations were retaliatory in nature. At the time of our original hearing, number one, I was a crime victim. I was entitled to crime victim services. Heidi had been arrested, and I was actually availing myself of crime victim services at that time. Crime victims are, under the Texas Constitution, protected from retaliation, and there is, as you know far better than I, a specific penal code that goes with that, and I believe that we have ample evidence to show that that code has been violated. And so, number one, I would again go back to the fact that there is nothing, frankly, at this point to base this original decision on, and I have been essentially severed from my relationship with my daughter. My daughter is in the hands of people that we have presented evidence that, as of the last meeting, and Miss Jenkins, Deborah Jenkins, that is, testified originally that she had one brief meeting with Heidi. That was in 2019, because, as I believe, the facts are voluminous here, but Deborah was estranged from Heidi at her choice. And I believe we've presented evidence to that effect. The last time we have presented evidence, the last time that Heidi saw Deborah in 2019 after her father's funeral, she prepared a plan, because I'm not sure if the court has looked at evidence about Heidi's PTSD that is frequently triggered by her family. And in fact, that was the reason for my original protective order request that landed us in your courtroom on March 2nd, 2022, when Heidi was still alive. And I specifically testified to you that I felt all of us were in danger, including Heidi, and that was largely because of her long history of abuse by her family and her PTSD in their presence. And so ultimately, I can't admit to something I didn't do. That would irreparably, my relationship with my daughter has already been irreparably damaged, and it appears that I'm unaware of. I presumably you have no position as yet, but I know that that is certainly Deborah's intention, and the financial devastation and the complete severing of my relationship. And you may recall in our original court hearing, I was my daughter's primary caregiver. Every allegation has been refuted, including Heidi's allegation in front of you that on the night of her arrest, I assaulted her. And of course, we showed you video of her initiating the assault. And we did turn up the fact that that is reflected in the police report. And that would be admissible under excited utterance. And for impeachment purposes, Heidi admitted that she assaulted me that night. So there was no question about that. I was a crime victim at the time, and there's quite a bit of evidence I've assembled that shows that these are simply retaliatory accusations, and some of that was included in my motion this morning. So,
okay, Mr. Friedman, I need to interrupt you,
Shirley,
because we are here not to relitigate prior court rulings, prior determinations from other hearings. We are here solely on the motion to enforce. And I have heard your response. I understand your position. However, most of what you've stated is not for today's hearing.
I will add one other thing if you don't mind, and I will make it brief.
Okay.
It was I'm not sure what conversations about withdrawing. There's some confusion because there's so many different case matters here. I was told very specifically by Ian that this enforcement issue would be a new action subject to a jury trial. And so once again, if we proceed today, all I will be able to do is to repeat repeatedly that I'm unprepared to represent myself without counsel. And it was not my choice that Ian withdraw from this. And I had actually requested that he stay on at least through the time that we resolved any issues regarding that. I asked him to request a jury trial because that was what I was advised. So once again, if we're going to proceed today, all I'm going to be able to do is say I'm not prepared to proceed without counsel. And so I did not want this hearing reset. I've been, as you may know, absolutely devastated by the delays. I've been devastated financially. This has cost me approaching 7 figures. My daughter, as I said, my relationship with her has been essentially severed. Effectively, that's been a smear campaign. And all I can say today is I'm not prepared to represent myself without counsel. And so if we proceed, that will be the same thing I say over and over. And I would ask the court's indulgence because that's simply the case, and it's not by my choice.
Okay. You have made that statement several times. I understand your position. However, this hearing has been set for some time, and you have known about Mr. Pittman's request to withdraw for some time, and you agreed to his withdrawal, and you knew that the hearing was set today.
Again,
There is no request for
Yes.
continuance verified on file in front of the court today. Ms. Kleinhans, please proceed.
Thank you, Your Honor. As if you've reviewed the motion for enforcement and clarification, you'll see it is way larger than I could possibly get to today. So the primary purpose of today is to just seek enforcement of the financial aspects, and then there's just a couple other ancillary issues that'll just kind of keep the case moving. But first and foremost, there are 2 important settings that we're going to focus on today. One is the April 2022 temporary order setting, where that was when Mr. Friedman was ordered to pay health and dental or obtain health and dental insurance. You might recall at the October 2023 hearing, he had only obtained coverage for the child in Texas that would not cover her where she lived in Maryland or when she moved to Florida in Florida. So my client was required to get new health and dental coverage for the child. So we seek the reimbursement for that since he did not have coverage just from April 2022 temporary orders until October 23, because in October 23, you did put specific orders in where Mr. Friedman was required to reimburse health and dental at a specific amount. So that's the only portion that it gets a little bit confusing, I would say, because the number just got a little bit reduced, where before there were orders, we were dealing with actual costs because he wasn't carrying insurance. And after that, we're dealing with the costs that you ordered. And then also in October 2023, you ordered child support. So he has not paid a dime since the October 2023 orders. So I believe that is going to be fairly easy to show you because there's just been zero payments. He did make a few payments prior to the October 2023 orders. We had agreed by a Rule 11 that his counsel later revoked that he was going to pay $500 a month in child support. So there were 2 payments prior to in child support. And then there was 2 payments in, I believe one was for an out-of-pocket medical and the other was for a camp. Or 2 camps. But it was a total of 4 checks. So I think the camps might have been combined, but we'll go through those. But the focus again is going to be, I think, on April 2022 to October 2023 period, because that is the only time that he paid anything. Our petitioners 5 is going to lay out, I put really in detail because I just want to get through this as fast as possible. These aren't large amounts and been really trying to keep down attorney fees, but on petitioners 5, we lay out all the different amounts owed when they were due, and you'll just see for all of them, the amount paid is 0. So moving on to the other issues, there was a May 24, 2024 order for reconsideration awarding attorney fees of about $58,000, and nothing's been paid on that. So we seek enforcement of that. And there were further orders for forensic psychological evaluation. We're pretty certain that has not ever been started. He was ordered to start that within 10 days of the order appointing Mr. Thorne as the psychologist. And we attempted to confirm with Mr. Thorne or Dr. Thorne. Dr. Thorne sent over his release. We sent it to Mr. Friedman's counsel, and they refused to sign it. So we believe that'll show he has not even started his forensic psychological exam, which we believe that was entered under the protective order and temporary orders. We believe that's a violation of both. We entered an order in December 2023. Oh. Did somebody say something? Okay. Yeah, we entered an order in December 2023 regarding production. There was an agreed order that Mr. Friedman would provide. What he had held out to us was his personal bank statements from this Chase bank account. You'll see a statement that we have that he produced. He has refused to sign the release after we subpoenaed them, and Chase sent us this release he has to sign for us to get him. He's refused to sign that despite numerous requests. He's also refused to sign required HIPAAs that were included in that same order that he had to sign. One being for his mental health provider. I believe it's his primary care physician that gives him psychiatric medicine, I believe was from his testimony at, I believe it was the October 2023 hearing. If we have time, and I'm not sure we will get there, this does still kind of tie into a lot of the other violations. Most of them focused around Mr. Friedman's communications with the child on Zoom. They're entirely inappropriate. It's almost like he looks at the orders, the standing orders, and what he says to the child, he's intentionally trying to violate them. But what I wanted to focus on first was the violations in communication pertaining to trying to persuade the child about how the trial's going, trying to persuade her how unfair it is, trying to persuade her that Ms. Jenkins is a bad person, persuade her that Ms. Jenkins' home is not his home. She'll be returning any day now. So those are the things we will touch on if we do have time. And then finally, the relief that we're seeking is on page 11 of P5. We're seeking that Mr. Friedman be held in contempt and confined to county jail until he complies with the financial orders. And they're listed right there. And we believe that is necessary given, just the motions Mr. Friedman filed, making these same arguments that have been denied multiple times, just trying to keep making them again, bringing them to court, but then not paying all his financial obligations. I think Mr. Friedman needs that wake-up call, and it's the only way that it may or may not happen. And from the time that he is The commitment is suspended. We were seeking that he be placed on community supervision, again, with another list of requirements until he's off of that, including, so those are on number 43 on page 12, but including that he get the forensic psychological exam done by Dr. Thorne. Our concern on that is if he doesn't get that done, that Ms. Fox, and I haven't really had a time to touch base with her too much, but that Ms. Fox will feel like she needs to issue a report before this comes out. And I think it's very important that we have the forensic psychological exam and Mr. Friedman's mental health records before the guardian ad litem issues her report. So, and again, I don't know if I have time to get to this today, but if I do, we're seeking that the protective order be reinstated based off of the violations, the prior violations of that protective order. Primarily the failure to get the proper psychological exam, which led to the order to get the forensic psychological exam, and then also the violations in communication. If I don't feel like I've really gone to enough of that today, we'll probably just hold off on that request so we can bring the full extent of all of the violations at the same time. But yeah, again, primarily we're here to get the finances to keep moving forward and to show the court the full extent of Mr. Friedman's violations of court orders. So thank you, Your Honor.
Okay. And Mr. Friedman, before you go any further, let me take a moment and go ahead and swear you in, since you're representing yourself and everything you tell me is really testimony. Do you swear or affirm that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
And that goes for what you told me earlier in this hearing, I presume?
Absolutely.
Okay.
Everything I told you.
Thank you.
First
All
time.
right. So Ms. Kleinhand's laid out generally the areas for the motion for enforcement. And I think that I take that as her opening.
Yeah.
So you are allowed now to give a brief opening to respond to what she has indicated she believes the violations are, and that she is seeking the court to confirm today.
Well, I would say number one, as I've already told you, and now we've heard that they're requesting me to be confined to jail and I've done nothing wrong. Regardless, I was advised I would be entitled A, to a jury trial today, and B, to an attorney. And Mr. Pittman would surely confirm that. He's obviously not available today. And so I am unprepared to respond to any of this. And the timeline regarding his withdrawal, I do disagree with. We discussed the withdrawal on the protective order appeal because we were doing two different things. And that was filed, I believe, in early December. And I was fine with that. That was something I actually wanted anyway. But regarding him withdrawing on the Sapser case, we didn't discuss that. And regarding the enforcement case, I was again specifically told that I would be A, entitled to a jury trial, and of course entitled to legal representation, including a court-appointed lawyer if I could not afford one, which, given the financial repercussions of this, because I will probably declare bankruptcy now, given what I'm told if you rule against me today, I may have to get a court-assigned reporter, attorney. So once again, I am completely unprepared for this. The motion is this fat. I was advised that it would be, again, a jury trial. And I would, of course, have an attorney for that jury trial. I don't have an attorney for this action. I'm completely unprepared to respond to this action. And the only thing I will say about the communications with my daughter, and Your Honor, with all due respect, you have ruled against me from the very moment that we have seen each other for the first time before Heidi tragically died 30 days later. There's two things I would like you to know. Number one, the relationship with my wife is not as it has been described here. I loved my wife, and everything I have done, everything, including requesting that original protective order, was to protect her as much as it was to protect my daughter, Harlan. My wife had been abusing drugs. She had gone off her lithium and had never, ever really come back to lability. And she was seeing a psychiatrist. And then when she got arrested, everything changed. And in the aftermath of that arrest, and I've again included these in my motion that I submitted this morning, and I do understand that that is certainly not ready to be heard today. Or she began threatening me shortly thereafter about signing things, and then she asked me how much money I wanted to disappear, and then she told me I wouldn't have a say in Harlan's living arrangements, and that was before any of this happened. This was so. I guess I'm begging you for some indulgence here, because once again, number one, my relationship with my daughter has been severed, and it has been intentionally severed. And, there was an email that may have been added into evidence at some point from Heidi. And in that email, which I could certainly find, and in fact, I have it here, one of the things they said, and I'm going to read this verbatim, and this is from January of 2019, which is very shortly after she decided to permanently estrange from Deborah. And her only contact with Deborah since this was her father's funeral. And again, at that time, she said, number one, she needed a plan to be able to deal with it because of her PTSD. And number two, in that plan, which has been submitted to evidence, she said it's way too soon for Deborah to have unsupervised supervision with Harlan, because the reason for the separation initially was Deborah driving drunk with Harlan in the car. Having a united front and sticking together is the most important thing, aside from Harlan, in the world to me. I could not live without you, Harlan or no Harlan. I couldn't live without you. I hate to say it like that, but you know what I mean, I hope. And we know my parents will try and break us up for years. It's hard for me because I think about feeling guilty for not letting my mom see Harlan. And then I remember what a psycho bitch she was the last time I let her take Harlan for a visit. They just effing, she used the whole world, but for decorum's sake, I will leave that out, scare me. They're willing to do almost anything, as we have seen, to break us up and get to Harlan. But there's this little voice that makes me feel sad for keeping them apart from Harlan. It's not easy for me. Please try and remember that. But my resolve to keep our family together and get us back to where we should be is my single most important focus. Remember that above all else. That more aptly describes the relationship with my wife. And unfortunately, and you have seen evidence from the Puerto Vallarta incident. And at that time, my wife had been abusing drugs. We got through that. She hurt herself. She resolved to stop taking some of the medication she was taking. And things were okay until she went off of her lithium during an extended business trip. And that was in September, shortly before she was arrested. And that was unintentional, I believe. I don't know. I'll never know. None of us will. I'm sure it was unintentional, actually, because for 3 or 4 days, I frantically helped her try to get lithium. She was in Denmark at the time, and it was very difficult. Ultimately, we were able to do it, but it took a number of days. And then since that time, she never really went back. But we would have likely gotten through this. And I would have to say, in all honesty, in all likelihood, had things played out a little bit differently, even frankly, if it weren't for COVID, because we weren't able to get Heidi a new psychologist and psychiatrist during COVID, which we needed to do because we just moved here. not only would she be alive, but we would be married. The nature of our relationship is not as it has been described, and not as it was described by Heidi to you in her one appearance in front of you. And the last thing I would add is that in the last time we were in front of you, we provided a transcript that had been previously unavailable, and it was from Carroll County, and it was from the second of two ex parte protective orders. This one was the first one. It's unclear what Deborah's involvement was. The second one, Deborah had admitted under deposition that she went to go get, and she couldn't remember the details. In that protective order hearing, which was only 24 hours prior to Ms. Kleinhand's first filing, the narrative that Heidi described of the events is so completely different from the narrative in the filing that was made. It's almost as if two different people were speaking. And frankly, that is entirely possible because the evidence in the filing that, again, Heidi never got to appear in contained evidence that was quite incriminating to her. She
Okay,
had.
Mr. Freeman, I need to interrupt you because we are way beyond the things that are set
That's
for
fine.
hearing today.
But I am that's fine, and I'm going to
But
wrap up here.
You have raised a couple of things that cause me to need to pause, and I need to check in with Ms. Kleinhands because my understanding prior to hearing from you this morning was that jail time was not being pursued. If jail time is being pursued in the enforcement, then I think Mr. Friedman has raised constitutional issues as it relates to his request for an attorney. So I need to get clarity from you on that, Ms. Kleinhands.
Okay, I mean, we certainly are. I can, if I could take a break and talk to my client to see if she wants to proceed without in order to go forward today. We can, but is there any chance I could just have a break to talk to my client?
I'm going to have Ms. Seeger send you a breakout room. We'll take a 5-minute recess for you to do that.
I appreciate it.
Okay. If everyone else would remain here in the virtual courtroom, but you may turn off your video and mute yourself in the meantime. Thank you. All right, it seems we have everybody back. Ms. Kleinhands, any update for the court?
Thank you, Your Honor. Yeah, we will, if we could just proceed on the issues where we aren't seeking contempt, we'd like to go forward with those issues and then allow him time to get an attorney before we reset or even come up with a reset date today for the financial support issues where we were seeking contempt.
Okay, I'm unclear as to what you mean by what you just stated.
Okay.
Are you stopping your request for jail time?
We will just go forward with the issues that we're not seeking jail time for, if we could, Your Honor, which those are the violations of communication with the child, and then the production items and the medical or the medical releases and the forensic exam.
Okay, and on those items, what is the relief that you are requesting for those?
For those items, well, we're seeking that the attorney fee award be confirmed and with interest. And then the just ordering like a set date. So you can still look under 43. That he has to complete I guess just another order giving him a date to start the forensic psychological exam if we determine that he hasn't started yet, or sign the release so that we can get those records. And And then, yeah, just the release is signed for medical and financial. And then finding that he violated the protective order and temporary orders, and reinstate the protective order.
Okay, so going forward on all the issues you've identified, you are not seeking jail time. I just want to confirm
Correct, Your
that.
Honor. Correct.
Okay,
May I respond, Your Honor?
yes, briefly.
The punishment that they're seeking is extraordinary, even without jail time. The financial scope is enormous. Ex parte Griffin, 682 Southwest 2D 261 262 Texas. They categorize that as the financial ramifications, which are lower than these, as serious punishment, and ruled therefore that the defendant, or I'm not really sure if it's the defendant, respondent, what the appropriate terminology is in fact entitled to a jury trial.
And
Okay.
Really, it's not that much additional, because we're seeking to confirm an award that's already been made. And the interest that we're asking to confirm on that is about $3,000. So it isn't substantial financial. That's the only financial request as part of those requests.
May I respond to that?
Briefly.
The total remuneration at stake here is well in excess of $50,000. The case that I mentioned was a far lower number than that. And once again, I'm of the position that, number one, I'm not prepared to represent myself without an attorney in a matter like that. I am of the position that there should be a jury trial. I would also note that there are two other issues at stake here. And one of them is that there is, and it's taken a while to get this done, but there is an open case, which Ms. Jenkins is both a perpetrator and an accomplice in, with APD, for interference with child custody right now. I would also note that U.S. Code 1201, which is kidnapping, says specifically that failing to return an abducted child, and by the definition of Texas Code, Harlan was abducted, taking them out of state, which Ms. Jenkins has already acknowledged she did. Whether she or Heidi did, we'll never know. And not returning them within 24 hours is a presumptive violation of that code. And that's federal kidnapping. Just by the virtue of Ms. Jenkins secreting Harlan, and even just not informing us of Heidi's death for 72 hours, puts her in presumptive violation of that code. That precedes the original hearing here. And so, again, it's taken some time for this to work through. But prior to this court's involvement, Ms. Jenkins was presumptively in violation of the federal kidnapping code. And while, again, I'm out of my depth here, I do believe the supremacy clause of the Constitution requires that or doesn't require, but does not allow a state to overrule or impede a federal matter, and in this case, it is a federal matter, and it's a serious federal matter, and it's a prima facie violation. And so once again, I come back to the same thing. There are serious legal issues at stake here. There's enormous financial issues at stake here, and then most importantly is the interest of a child. And I require, number one, an attorney to deal with those because, as I said, just the financial ramifications of this has indelibly altered my daughter's future, and the financial punishments that they're seeking will destroy that. Her college fund has already been expended in litigation. Her sister's new condominium has already, she's left Austin because this proceeding has prevented me from giving her the money. I hope to allow her to do that. And we have an open criminal investigation in which Deborah and Heidi, and as you know, that they would be equally liable for any of Heidi's violations as accomplices, and they would also be, under Texas Penal Code, they would consider to be accomplice witnesses in crimes that predate our original appearance in front of you. And once again, I'm not an attorney, but it would be an enormous logical fallacy to allow accomplice witnesses whose, by definition, under the Texas Penal Code, their credibility, they cannot be considered credible without corroboration. And there has been no corroboration here whatsoever. Everything that has been said in front of you has come from either of the Ms. Jenkins mouths. Everyone who's testified in front of you has received their information only from Ms. Jenkins and Ms. Jenkins' mouths. And so, as accomplice witnesses in crimes that precede our appearance in front of you, their testimony could not be considered credible anyway, and the testimony of the witnesses who are based on the hearsay that they've given them could not be considered credible. And that is one of the reasons that, although I was not able to include that particular piece in my motion that I filed this morning, and I will include them in an amended motion, and I will get an attorney to help with that, hopefully. Once again, I believe that the ramifications of what they're seeking, combined with the fact that they're accomplices in an open criminal investigation and will be accomplices in a federal one, which I don't have a case number yet, but expect to soon, would obviate all these proceedings.
All right, Ms. Finance, why don't you put on your evidence of the items that you discussed earlier?
Yes, Your Honor. I'd like to call Howard Friedman.
All right, Mr. Friedman, you're already under oath, so counsel, you may proceed.
All right, thank you. Mr. Friedman, where are you currently employed?
I'm self-employed.
And what do you do for self-employment?
Well, prior to this tragic series of events, Heidi and I were in the aircraft business, and I also was in the solar renewable business. The original reason we came to Austin was because of an enormous solar project that $100 million plus solar project that we had won, and that was my other employment. That project was delayed because of COVID and then ultimately went away. I intend to get back in the aviation business, but as evidence we've presented shows, and including a text from Heidi about how Ms. Jenkins, Deborah Jenkins, that is, and Justin Jenkins were doing everything possible to destroy our careers in aviation. And I believe that text is in evidence.
Objection unresponsive.
Sustained.
I'm just asking you how you are currently employed. You responded you're self-employed. I just
Self-employed.
want to know how you're self-employed.
I am self-employed in two capacities. I am the managing partner of a solar distribution company. And I am again the managing director of a aviation company where I have not been able to actively participate because of the smear campaign within the very small aviation industry. Those are
What is the name of the solar distribution company?
that is Alternalux LLC.
Can you spell that?
ALTERNUX LLC.
And are you the only employee in that entity?
I am not an employee in that entity. I am a contractor, just as we were in Blue Chip Jets. And I would like to add at this point, I'm not prepared to answer any additional questions without an attorney.
And how much do you make as a contractor for that company?
Just as in the jet business, and as Miss Jenkins, Deborah Jenkins, that is described many in one of her things, those businesses have what we call chunky revenue. They don't have typically regular revenue. The revenue comes in based on a transaction. It could be a jet sale, or it could be a solar project. Once again, I'm not prepared to answer any additional questions really about anything without an attorney present.
On average, how much did you make in that company a month in 2024?
I'm not prepared to answer any additional questions without an attorney present.
So you don't know how much you made?
I'm not prepared to answer questions without an attorney present. I was advised that I would A, have the right to counsel, and B, have the right to a jury trial, and I am simply unprepared to answer any questions without an attorney present.
Objection non-responsive, Judge.
Sustained.
Ask you to instruct the witness to answer the question.
Mr. Friedman, answer Ms. Kleinhand's question.
Which question would you like answered?
How much did you make on average a month in the Alternex LLC managing partner position?
As I said before, the revenue is chunky. It's not a monthly thing.
On average.
There is no average.
How much did you make last year in 2024?
Nothing.
How much did you make in 2023?
I would have to check.
Did you make any money in 2023?
I would have to check.
So you don't know.
I do not know right this moment.
And your, I believe, jet or aviation company, what did you make in 2024 at that company?
As I told you, the aviation company I have not been active in. That company, when Heidi absconded, she owed me about $100,000 out of that company. She had that in the bank account. That's disappeared.
Objection non-responsive.
Sustained.
How much did you yourself make in profit in the aviation company in 2024?
I don't know. Oh, well, that'd be nothing. Excuse me.
I'm sorry, did you say nothing in 2024 as well?
Correct.
So you made no money in 2024?
Correct. And I would add something, though. Again, I am unprepared to answer questions without my attorney. However, we could go back to prior testimony from Deborah Jenkins, where she specifically notes that.
Objection non-responsive.
Sustained.
Did you make any money in income in 2025?
Over the last few weeks?
From January 1st, 2025 to February 21st, 2025?
No.
Do you have income in any other capacity over 2024 and 2025?
My income results primarily from capital appreciation. And I don't know what that is.
Okay, what capital assets are appreciating?
I would have to go look.
So you're-
I am simply unprepared to discuss this without an attorney, Your Honor. We can continue and she will object and you can continue sustaining them with all due respect. I am not prepared to discuss this without an attorney. These are sensitive issues. I was advised that I would be entitled to counsel by an attorney. I've quoted case law that says for a $50,000 amount, that it's a
objection non-responsive.
back to the quote.
Mr. Friedman, we took a look at the case that you cited before. It is not applicable to this circumstance in which we are in court today. You're not entitled to an attorney because they're not seeking jail time. They are not seeking contempt. They are seeking only a few items that counsel stated earlier.
Are they seeking
In any case,
are they seeking in excess of $50,000?
Mr. Freeman,
I
mentioned earlier, we are not relitigating the entire case today. And that is over and over again what it appears to the court that you are trying to do.
Well, again, I've made that point all along. However, my question was not about that. My question was simply the amount of money at stake that they're requesting.
I think the amount of money that was referenced are amounts that were previously awarded. And Ms. Jenkins is seeking a finding by this court that you have not paid any of those amounts that were previously determined by the court.
I am not prepared to respond without an attorney, Your Honor. Unfortunately, I've been misadvised because I was under the impression, and of course, as a U.S. citizen, I was under the impression that I would always have the right to an attorney, and it was not my choice that my attorney withdrew, and it was not his choice other than medical issues. I cannot respond to this without an attorney. If the nature of this proceeding is going to be that Ms. Kleinhans is going to ask question after question, and I am going to respond the same way every time, and then ultimately you're going to award what they ask for, I would suggest that perhaps we would move forward to that because I simply cannot proceed without an attorney.
Okay, the answer that you've given is not an appropriate answer in a civil family law proceeding such as this. You've known about the hearing. You agreed to let your lawyer go without bringing a new one.
Ma'am, I was served on this hearing 19 days ago.
And you'd been copied for months on the correspondence between the parties and your counsel about their attempts at service and about your lawyer's request to withdraw and about the reasons for it.
Ma'am?
So in criminal court, you can plead the fifth, but you cannot come in here and say I'm not prepared.
But I am not prepared because the fact of the matter is that I have not, you may, I would have to go back and look at whenever this was filed. When it was filed, Mr. Pittman was my attorney. When it was filed, Mr. Pittman told me I was entitled to a jury trial, and therefore, at that time, whenever it was, and I don't know that it was months at all, I would have to look, and we could go ahead, I'm sure, look at that. I was told I would have, number one, the grounds to ask for a jury trial, and that was simply my intention. Number two, at that time, Mr. Pittman was not withdrawing from my case. And so neither he nor I presumably, certainly not I, took any steps to prepare for a case that we believe was going to be heard in front of a jury. Now, you're telling me I have been misadvised. And unfortunately, given the circumstances, and again, since my agreement with prior counsel to withdraw because of his circumstances, which verbally was, I believe, in maybe about 8 weeks ago, and then we discussed the appropriate timing of that. And again, I was served on this proceeding 19 days ago. And so I am simply unprepared to proceed without an attorney. And you're telling me that I was misadvised. And so I am here and I am simply subject to the whims, yours. And that's about it. I cannot defend myself without an attorney. These are serious issues and I have no ability to respond to them appropriately without a lawyer.
Right, Ms. Kleinhans, why don't you proceed with your examination, or if you have evidence or want to call another witness?
Yes, Your Honor. Mr. Friedman, have you filed taxes in the last 10 years? Federal taxes?
I filed extensions for taxes. And part of the reason for that is that my wife, Heidi, was included. I have filed for taxes. I can't remember the last year, but for the last couple of years, because again, of the nature of the business, until shortly before Heidi absconded, when we had a significant piece of revenue.
So you believe you filed at about 2022 was your last filing, or 2021?
I would have to look. It may have been last year. I have to look. I don't know that off the top of my head. I will again repeat, I was not prepared for this today, and I'm not prepared to respond without an attorney. Unfortunately, what I'm being told is that I'm being misadvised. So presumably what we'll do is you'll continue to ask questions. You will object as
Objection non-responsive.
correct.
Disdain.
And do you receive any income from any trust, or have you received any willed assets?
I'm not prepared to respond to that without an attorney.
Yeah, I will presume that's a no unless you answer otherwise.
I am not prepared
that
to
accurate?
respond yes or no without an attorney. You can make presumptions as you like, but I do not intend for my response to mean either yes nor no. I am simply unprepared to respond without an attorney.
Your Honor, is there any way that I can ask that anytime he gives that response that we should presume that it's against his interest to answer? And I mean, at this point, honestly, I need some help because I need to get my evidence in. I can move on and just hope that you're presuming.
May I make a point?
But
No. Ms. Kleinhans,
frustrating.
what's the legal basis for your request?
Well, this is on being able to pay attorney fees. But yeah, I can move on if that's what the court prefers.
Well, I think you have come in with a list of things you want to accomplish, and you may or may not be able to do that with this witness or another witness or other documentary evidence, but it is not my role to aid or assist.
Yeah, no,
and I think the way that
100%.
you asked.
Yeah, I 100% understand that, but
May I make one?
I mean,
quick point?
yeah, I'll just proceed, Your Honor. Thank you.
May I make a point, Your Honor?
Yeah.
No, we are in the petitioner's motion. You'll be able to respond when she concludes.
All right. And Your Honor, may I share the screen?
You may.
All right. And this is proposed petitioner's exhibit 27. Mr. Freeman, does this appear to be a true and accurate copy of your IRA from account number 8100?
It does appear to be. Yes, it does.
Okay. And Your Honor, I move to admit petitioner's exhibit 27.
Any objection? Hearing none, it's admitted.
I would object on the grounds that I've already mentioned, that I do not have an attorney present, and I would also add that I was advised that while taking the fifth would be a presumption, allow an inference of a presumption against me, that simply stating the truth, which is that I cannot answer without an attorney present, is not a presumption entitled to a negative presumption against me. In terms of the IRA, I don't know what you're looking at here. I can tell you that I've had to expend, as I already told you, extraordinary amounts of money. And if you want to cut to the quick, if there ends up being a significant judgment against me at the end of this proceeding, I will be declaring bankruptcy.
Okay, the objection is overruled. The exhibit is admitted.
Thank you, Your Honor. All right, and then I'm going to show what's been marked as petitioner's exhibit 28. All right, Mr. Friedman, does this appear to be a true and accurate copy of your Schwab account 8101?
It has my name on it. It certainly does.
Okay, Your Honor, I move to admit petitioner's exhibit 28.
Any legal objection to the admission of the document?
No, ma'am.
It's admitted.
Right. And I have petitioner's exhibit 29. It's the Capital Group Fund. See your name on it, account number ending in 3620. That's petitioner's exhibit 29. I move to admit petitioner's exhibit 29.
Sure.
No objection. It's admitted.
Okay, and petitioner's exhibit 30, a fidelity statement with account number ending in 0975. Move to admit petitioner's exhibit 30.
I will raise an objection, and Your Honor, you may consider this a running objection.
What's the basis?
The basis for the objection is that all of these financial disclosures are based on fraudulent. You have said that we're not relitigating this, and I am objecting on the basis that this was confidential information that Deborah Jenkins was not entitled to, because Ms. Kleinhans was not entitled to represent her, given that she was Heidi's prior counsel, and she owed Heidi the duty of confidentiality. Her appropriate role in this case, because of Heidi's death and because Ms. Jenkins, Deborah Jenkins, has said very specifically, outside of the circumstantial evidence that she had no possibility of firsthand knowledge, she has specifically said she is only passing on Heidi's allegations. That was in depositions in July of 2023, very specifically. Therefore, everything in this case comes from Heidi. There was Ms. Kleinhans was Heidi's prior counsel. I could look up the rule of professional conduct. She owed Heidi the duty of confidentiality. Further, and that's, I believe, 105 or 106. Further, I believe it's 308 that says her appropriate role in this case, given the fact that Ms. Jenkins, who was estranged, and so any exposure that she's had to our lives happened only in the very brief 6-week or 8-week period between Heidi seeing her and Heidi's death in her home. Therefore, Ms. Kleinhand's role is actually a witness in fact. And therefore, furthermore, all of these disclosures are confidential information that she was not entitled to, because Ms. Kleinhand's was not entitled to take this case on Deborah Jenkins' behalf. And without doing so, these disclosures would not be necessary.
I'll overrule the objection. The exhibit is admitted.
Two more. It's petitioners exhibit 30 Sun Trust ending in 4200. And I'm sorry, that was petitioners 32 and petitioners 33 Sun Trust ending in 63.
I repeat-
6463.
I
Mr.
repeat
Friedman
I repeat
are
my own objection.
petitioners 32 and 33 true and accurate copies of the Sun Trust statements to the best of your.
To the best of my
Okay.
knowledge, they are, and I repeat my objection that neither you nor Ms. Jenkins is entitled to this information because of your improper representation. But yes, they do look true and accurate.
Your Honor, I move to admit petitioners exhibit 32 and 33.
Okay, the objections are overruled. They are admitted.
Mr. Friedman, how much have you paid your attorneys to date from the beginning of this representation in 2022 to the present?
Would that include just Travis County, or would that include the malicious prosecution in Carroll County, which has also required me to appear, including for following your orders, Your Honor?
Related to this case, Mr. Friedman.
Say about approximately $400,000.
Okay, and where did you get that money from to pay that?
I got that money from my family.
And which, was that one family member or your parents? Or more
I will not
specifically?
answer that question without an attorney present.
Objection non-responsive.
Sustain.
And you stated that you are going to continue to seek an attorney. Where are you going to obtain the fees to pay for that attorney?
Well, that's a great question. So I'm going to do several things. I am looking for a pro bono attorney. I have several organizations who work with cases that are like this one, where there's been an extraordinary injustice, who may be able to require legal assistance. I also have identified a couple of attorneys who, just because of the enormous constitutional ramifications, may take this, but as of right now, I may request that the court appoint an attorney for my inability to pay, depending on what that looks like. I'm simply unsure right now. This is relatively new to me, and once again, I expected that I would be retaining an attorney, not for today, but for a jury trial. So I've been misadvised, and I cannot answer your question.
Where were the funds deposited? Which of your bank accounts were the funds deposited that you obtained from family to pay your attorney fees?
I will not answer that question without an attorney present.
Objection non-responsive.
Sustain.
And were there any other bank accounts other than the ones we admitted from P27 to P33 that you have that were not included in those that were admitted?
At the time I made my disclosures, all of the bank accounts that I had were included, to the best of my knowledge. That was quite some time ago. I think it was 4 years ago now, or 3 years ago now, whenever it was. Anything further, I'm not prepared to respond without an attorney present.
Objection non-responsive.
Sustain.
Going to pull up, and Your Honor, can I ask that the court take judicial notice of the case file?
Yes, I will.
Thank you. All right, so I'm just going to pull up petitioners 18 just for reference, which is part of the case file. It's the order on the motions for reconsideration. And Mr. Friedman, on May 10th of 2024, the court signed this order on your motions for reconsideration that awarded attorney fees of $58,862.50 at an interest rate of 8.5%. Do you recall that?
Well, at the time that those orders were made, my counsel told me that there was no possible legal basis for such an.
Objection, non-responsive.
Sustain.
Do you recall that that order was made? Or were you aware that this order was made?
I'm not prepared to respond without an attorney. At the time that that order was made, I was represented by an attorney and strictly following his advice and looking at documents and as he suggested, and I cannot recall if this was one of them.
Is it common for you to not recall what's in orders?
Well, there have been quite a few documents here, but as I just said, because I do, despite the fact that my income has been severely curtailed because of the smear campaign that this entire litigation represents, and based on these retaliatory allegations, and as a crime victim, I look at what my attorney tells me to look at. And in this particular case, my attorney told me there was no possible legal basis for it. So I cannot recall if I looked at it or not. I do recall him telling me there was no possible legal basis for it.
Have you made any payments on that $58,862.50?
I will not answer that without an attorney present.
But you have no record today that you brought to the court that supports that you've made any payments, correct?
We can go back to my statement at the beginning. I am completely unprepared to respond to this hearing. The judge has decided that that is not valid. So all I can do is say the same thing over and over again. I'm not prepared to respond to any of these questions without an attorney present, as I was advised I could have. And furthermore, I was advised that this would not be a hearing on this matter today, but that it would be a jury trial to be scheduled later. I am completely unprepared for this hearing. I request an attorney, and if the judge has informed me that I was misadvised, so be it. I came into this hearing believing that I would be entitled to an attorney in a jury trial. I have absolutely no ability to answer these questions. And since everything I have said has been used against me and everything I have done to follow orders and to try and protect my family has been used against me, and I will not respond to any further questions like this without a lawyer.
Your Honor, can we just assume that that is his running objection so he doesn't have to keep responding that way and he can answer anything else you might have to add to that, but just to speed things up so we don't have to keep listening to that same response?
I think what you're telling me is you are going to pass the witness?
No, I mean, so he doesn't have to keep repeating it. I'm just asking if you can just consider that a running objection to every question I ask going forward, so he doesn't just keep repeating himself.
I don't know that it's an objection. It's his response for what it's worth, which
Yeah, I guess
is
you're
very
right.
little.
Your Honor.
All right, I'll move on.
Your Honor,
And
I
Mr.
would be happy to consider a running objection.
Well,
Okay, fair enough. Go ahead, Ms. Kleinhans.
all right, Your Honor, I'm going to share. It's the further modified and further temporary orders. And at page 13. Mr. Friedman, do you recall, or do you see that part of this order is that you were ordered to undergo a forensic psychological evaluation within 5 days of the approved list of providers?
I object on the grounds that I anticipated a jury trial, was advised I could have a jury trial, and do not have a lawyer present.
Objection non-responsive.
Sustain.
Then on petitioners 19. This is the order for forensic psychological exam. Do you see it says that you're ordered, again, to have the forensic psychological evaluation with Dr. Thorne. And you
Counsel.
are to contact Dr. Thorne within the 3rd business day following the date the order is signed. You
You're
see
not
it?
showing this right screen,
Oh.
counsel.
I'm sorry. I don't know how I keep
Don't
doing.
see it.
Appreciate that, Your Honor.
Sure.
All right, Mr. Friedman, do you see in this order on the forensic testing that you were ordered to test with Stephen Thorne?
I
And
object.
schedule that appointment by the 3rd business day following the date the order is signed.
I will not answer without an attorney present, and I was under the advice that this would be addressed in a jury trial.
All right, Mr. Friedman, you're entitled to a jury trial in a final merits determination of the SAPSR hearing. That's not what this is. This
Your
is a
Honor,
motion, an enforcement motion. And I've
Your Honor.
already explained you don't get a jury trial on an enforcement motion. So please
But what
stop interrupting with your assertion. We know what your assertion is.
Okay, so how would you like me, in the interests of what you would like, since you're overruling these overseeing these proceedings, and since you all understand what my objections are, what would be the appropriate response?
You've made your objection. It's in the record. It's been overruled. You do not need to continue to make the objection. The issue has been raised and ruled upon, and there is no need to continually raise it.
I understand. I'm asking how you would like me to respond if that is my response. What you have told me about not being able to A, have an attorney, and B, have a jury trial is news to me. Those are, I could even show you emails from Mr. Pittman. Therefore, it all holds. You're telling me I was misadvised. That doesn't change my situation. So if you would instruct me how to respond, I would be more than happy to do that. And I would be more than happy to comply with Ms. Kleinhand's point of speeding things along if you would just instruct me.
Under the rules, I am not permitted to give you legal advice. You will need to seek that from other counsel.
Understood. I'm asking for, in the interest of this proceeding, to your point of making the same objection over and over, how I should do that. And it's your proceeding.
Okay, and I thought I was clear, but I'm saying you've made your objection. It's been ruled upon. You do not need to continually raise the same issue. I understood it. I made a ruling on it. And it does not need to be raised and answered to every question Ms. Kleinhand's asked. Thank you. All right, counsel, it's time for us to take our morning recess. The court reporter's been on the record for over an hour and a half, so we're going to take about 15 minutes. Let's see, we'll come back at 10:50 or so. All right, thank you.
Thank you.
Feel free to mute and turn off your video in the meantime.
All right. Thank you, Your Honor.
Looks like we have everyone with us. Ms. Kleinhands, you may proceed.
Yes, Shauna, thank you. I'm going to share screen for petitioners, proposed exhibit 26. And Mr. Friedman, do you recognize this Blue Chip Jets Chase Bank statement ending in 8158 as, do you recognize that statement at all?
Oh, you're on mute, Mr. Friedman.
Okay. Enlarging my screen to have a look at this. Yes, I do. But only because
Objection non-responsive to the explanation.
All right, I'll sustain.
And do you believe this is a fair and accurate copy of one of the Chase Blue Chip Jets bank statements?
I can't answer that because I wasn't entitled to answer the prior question, which would explain precisely. I recognize what's highlighted there. That's the money that Heidi was paying for the Airbnb that she was, we eventually found out she was secreting Harlan in for the month of March.
Okay, so you made these highlightings on this paper, correct? You made this key and did the highlightings?
No, I don't know who did that.
Okay, but you've seen this document before, correct?
No, I don't believe I have, actually. I saw one from the same account, which Heidi generally managed from before she absconded, which had significantly more money in it. I think about $100,000 that disappeared, but no, I don't.
Okay, well, I'll represent to you, your counsel produced this statement as, these are your initials, HBF, as the fourth document in your disclosure production. Does that refresh your memory about you having this document in your possession?
When was that, please?
It was when you did your disclosure production, so your initial production.
Was that at the time of the initial hearing?
Mr. Friedman, I'm not the one answering questions here. I'm asking you how this got produced if you never had that in your possession, or if that refreshes your memory to having this statement in your possession.
I'm not sure what the question is.
Does seeing your Bates numbered production number right here showing that you produced this as the fourth document in this case refresh your recollection about whether or not you had this statement in your possession?
Sure, I surely had that statement in my possession. I was able to get these bank statements after Heidi absconded, and so I turned them over as evidence for the fact that a substantial amount of money has disappeared, as Heidi threatened it would, and before this action proceeded. That's
all right,
specific.
and then you can confirm that this appears to be a fair and accurate copy of this Chase statement that you had and produced.
It is. I should add, though, that even though that Heidi was supposed to provide me access to this account, I had no access to that account prior to her absconding.
All right, in your honor, I move to admit petitioner's exhibit 20 or 26.
Any objection?
The only objection is this is a Blue Chip Jets account. Heidi was the managing director of Blue Chip Jets. She managed all the money. I did not have access to that.
I need a legal objection, not an explanation of what it is. Do you have a legal objection?
The legal objection is that it's not my money. It's not my account. So,
in spite of the fact that you produced it in this case, overruled.
I was able to produce it as part of my own discovery of Heidi's assets.
Okay, I don't need anything more from you, Mr. Friedman. The objection was overruled. Ms. Kleinhans, we only have about an hour left.
Yes.
So you need to move it along.
All right, thank you, Your Honor. And Mr. Friedman, this orange, the HBF, do those represent your charges, the Apple Cash that we see right here? Did you?
No, I had no access to this account whatsoever.
All right. All right. Do you remember this agreed order that was reached on July 31st, 2023 about production and about release of mental health information?
I signed, I do remember the order, and I signed, I think, 8 or 10 HIPAA releases there.
Okay, objection non-responsive to part going forward. My only question. whether or not it's not, you remembered it. And you see on here that you agree to turn over what was held out as your personal bank account chase statements ending in 8158. And right here, I was thinking both council signed off to it, but I think what happened is we read it into the record. Do you recall reading that agreement into the record in front of Judge Mozzie?
No.
Okay. But you haven't provided any release for, let me back up. Is your only mental health care provider your primary care physician?
I'm not prepared to answer that question without my attorney.
And have you signed a release for any mental health provider that wasn't otherwise court ordered?
I signed a release for the mental health provider who did my thorough psychological exam, and I further signs a bunch of other HIPAA releases, but I think it was for my primary care position at the time.
And you do still currently receive prescription medications for mental health issues, or is that correct?
As noted by my prior primary care physician and psychologist, the mental health medications that I am receiving are as a result of these proceedings.
And your primary care physician is the physician that prescribes those, correct?
At this time. I
And
further note, if you would like, that those medications were prescribed in concert with the psychologist or psychiatrist, excuse me, who did my mental health evaluation. So there was no need for him to prescribe on his own, since my primary care physician, who was aware of the trauma of this situation and the trauma of the continuing injustice and losing my wife and having my daughter taken from me. I'm not sure of the interplay between the two.
objection unresponsive.
Sustain.
All right. And the during the supervised Zoom calls you have with your daughter Harlan, do you understand during those calls that you're to refrain from, per the protective orders, from being annoying, harassing, or embarrassing to her?
Absolutely. I've never been annoying or embarrassing or to my daughter at all.
And you understand from the temporary orders that you're and the protective order as well, that you're not to discuss the litigation at all with your daughter Harlan.
Well, see, the problem that I face with my daughter in this instance is that our entire life, her mother's life, her mother's death, going back to the time when the original fallacious order that was issued by—
Objection non-responsive. Mr. Friedman, it's a yes or no question.
What's the yes or no question?
Yes or no, you understand from the protective order and the temporary orders that you are not to be discussing the litigation with your daughter Harlan.
I don't discuss the litigation with my daughter Harlan. What I try to do is maintain a link between her and me, which has been indelibly severed by these proceedings. But I do not discuss litigation with her other than to let her know I am continuing, as I have been since before these orders, to get her—
Objection non-responsive. I got to keep this moving. Please answer yes or no. It's yes or no. Do you understand that part of the orders are that you are not supposed to discuss the litigation. It's that the part you're missing is understand. You understand that?
And the answer is that this litigation and this case, do you understand? I have
Objection,
not had a
non-responsive.
supervised conversation with my daughter since before her mother died. They withheld communication for 2 months before her mother died. I've never been able to discuss that with her. I was
Objection,
unable to. I
non-responsive.
went to Maryland to try and get her to go
Okay,
see her
I'll
mother's
sustain.
body. And I was prevented from doing that by a fallacious protective order. And since then, every aspect of our relationship in life is indelibly linked to these proceedings. And so there is no way
Objection,
that I can have a
non-responsive.
meaningful conversation with my daughter
All right,
without
Mr. Friedman,
these.
I'd already sustained. You need to wait until a question is on the table. Ms. Kleinhans, do you have much more for this witness? I see the guardian is here. I know you might be calling Ms. Jenkins. We are running low on time, so you need to efficiently use what time is left.
I understand, Your Honor. And Mr. Friedman, you understand that you're not supposed to psychologically pressure or influence Harlan's opinion about legal proceedings pursuant to the temporary orders entered in this case. Yes or no?
Of course.
Okay. And you'll agree with me that there have been numerous times that you talked to Miss Jenkins, or that you talked about Miss Jenkins to Harlan and called her a terrible woman, correct? Yes or no?
No, I don't recall that at all. In fact, I've been incredibly, given the fact of what this woman has done to my family, including the 5 years preceding my wife's death, because we were running from this woman at my
Objection,
wife's choice,
non-responsive.
at my wife's choice, at my wife's choice, and I
Sustain the objection, Mr.
never,
Friedman.
ever,
Wait
ever
for
said the first
question.
bad thing about this.
Okay, when an objection is sustained, you wait for the next question.
Can I ask that you make a finding of contempt and just that the contempt hearing be held when we hold the enforcement hearing? Where that would be the point that he'd be allowed to have counsel, is my understanding. That's not that you can't have a finding of contempt in this hearing, so this hearing can proceed with some sort of decency in his responses.
I do not follow your request.
I'm just asking for a finding of contempt, not that any sort of jail time be considered today, but that be determined at our next enforcement hearing where he would have counsel. Just contempt based off of his refusal and failure to follow your instructions and to answer the questions.
And what's your legal basis for that request?
Just that the judge has wide discretion to keep the courtroom orderly and to maintain order, and without being able to have that power to do that with a pro se party, all powers would be exactly like it's going on in this case. Pretty much muted, where I just have to move on and he's not cooperating and there's nothing else we can do. But yeah, I do have case law on that. Let me just pull that up.
Well, let me say I will carry forward your request to the next
Okay,
hearing.
yeah, I could brief
And
that
then
too.
you will be able to provide whatever authority you have that supports that request in between now and then.
All right, thank you, Your Honor.
Okay, thank you.
All right, and then, yeah, I'll pass the witness, Your Honor.
All right. So, Mr. Freeman, you are representing yourself. So if you have any additional testimony to offer to the court, you heard the issues that are being raised. I'll go over them again. I think they maintain that you have not paid the award of attorney's fees that was previously rendered, that you have not submitted to and completed the forensic exam, psychological, or psychiatric exam, that you haven't returned the medical releases, and that you have had communications with the child that are in violation of the standing order. So anything else to offer the court on those contentions? And if you could be brief, because we are running low on time.
All right, well, starting with the last one. As I have said, I have been incredibly, and understand, as I have said before, and I can produce ample and have produced ample documentation to this effect. This woman, Deborah Jenkins, is someone my wife was running from. She did not even want her to know our address. And in fact, that evidence has been placed in the court in the motion I filed and in the previous one. She has, for the last 4 or 5 years preceding my wife's death, done everything possible to terrorize us. And you've seen that in my wife's own words. And despite all that, and despite the fact that this is, frankly, a kidnapping, I have maintained the utmost restraint to ensure I have never said the first bad thing about this woman, even though if my thoughts were words, I would, but I have maintained the utmost in restraint in doing that. And the complication that we have here is that Deborah's weaponization of these orders and the communications are you know, there's a if I go back to the Texas Family Code 15301, public policy. Policy of this state is to ensure that children will have frequent and continuing contact with parents who have shown the ability to act in the best interest of the child. Well, everything I have done and everything I ever do is in the best interest of my child. For instance, if we discuss legal fees, this is my child. I intended to leave her a legacy. I intended to leave her money. I intended for her older sister to have a legacy so that they could live their lives. These fees have destroyed that. And paying them is not in her best interest. It's precisely to the opposite of her best interest. And I have been repeatedly put into a position where her best interests are not served by the court orders. So nonetheless, I have done everything possible to follow the court orders while also balancing or attempting to balance, because frankly, it's impossible. It's a catch-22 for me to try and maintain my relationship and maintain some semblance of a future life that has some semblance to the one that she was accustomed to before she was abducted. And so ultimately, everything I have done is in my child's best interest, both before and currently. In terms of communications, I will state very specifically, I've shown extraordinary restraint to ensure that we have not discussed this case. And yes, it is very difficult because this case is our lives. One day I was Harlan's primary caregiver. As her principal said in the CPS report, there was no indication of a problem, and one day she just disappeared and was taken away. And that's precisely what the situation was. My daughter was perfect. There was never any indication of a problem. And so what I am trying to do, just as Texas public policy is to maintain some semblance of a link to our prior life. But I have never said anything bad about Deborah.
Okay, anything else for the court? Did you complete the examination that was court ordered?
Not at this time.
And I take it based on what you told me that you have not paid the attorney's fees.
Well, I will not be able to. I'll be declaring bankruptcy.
And have you provided the medical releases that were ordered?
Yes.
I'm sorry, I didn't hear.
Yes.
You have?
Many times. That goes back to the first year of these proceedings. I stayed up late one night doing these things for, I think it was in 2022, the November, December of 2022. I did them again in 23. I did them again, I think, last year. So I provided so many HIPAA disclosures, I don't even know what they all are. Or excuse me, HIPAA releases. My apology.
Okay. All right. Do you pass yourself as a witness?
Do I have an opportunity to recall myself?
Given that we only have 45 minutes, that may or may not be possible. I see there are a couple of other witnesses that may or may not be called in the courtroom, so we will see.
Well, I have perhaps additional things to say, but not at this time. So if we don't have time, then we don't have time. So I will pass my.
Ms. Kleinhans, anything else for this witness, or you have another witness or anything else to offer?
Just one more question. Isn't it true, Mr. Friedman, you have not signed the HIPAA release for your primary care physician or any of your personal mental health treatment providers? Personal, not court ordered.
I don't have
Yes or
any
no?
personal mental health providers at this time. I had them at one time, and those releases were signed, and those, in fact, not only were those releases signed, but I believe that at the last hearing, which was so long ago, I can't remember. I think it was a year and a half ago, or last November. Anyway, yeah, I signed releases for all my providers.
And you stated to the court today that you have a doctor prescribing you mental health medications. Isn't that correct at the present?
I don't know what you would consider to be mental health medications. If you mean Valium, I've discussed that before. I've been prescribed Valium, and I've been prescribed bupropion, and that's the same thing that I'm doing now.
And who is prescribing those to you?
Discussed that in the past. I already told you that those were prescribed originally by my primary care physician, and after my psychological evaluation, which was completed, and I will note that the doctor did tell me that there was no need for any additional exams. Those medications aren't to help me with any issue like Heidi had, like lability or bipolar or PTSD, which I do have now. So I shouldn't say that.
Objection, not responsive.
It's not unresponsive. You're asking me about psychological medications, and I'm telling you what they are.
Mr. Friedman, when there's an objection, you need to pause for the court to rule on them. Okay, that's how that works. I'll sustain.
And I'll pass the witness, Your Honor.
Okay. And any other redirect of yourself, Mr. Friedman?
No.
Anything else?
No, Your Honor.
Okay, thank you. All right, Ms. Kleinhans, any other witnesses?
Yes, I'll call Miss Deborah Jenkins.
Okay, Ms. Jenkins, if you would unmute, go ahead.
All right, thank you. And Ms. Jenkins, we're going to skip right to the Chase bank account and mental health records. Since that's where we ended with Mr. Friedman, but did you ever receive a signed release for those Chase bank records that we saw were ordered pursuant to an order of production?
No.
All right. And did you ever receive the names of, or actually strike that? Are you asking the court to make Mr. Friedman produce the financial records and release the mental health records as part of the enforcement order today?
Yes.
All right. And Have you ever received, and I guess, actually, I'll strike that because Mr. Friedman admitted that he didn't pay attorney fees and admitted that he did not have a forensic psychological exam. So as far as the violations, in communication with the subject child, was Mr. Friedman, or actually, is it your understanding that you are to supervise the calls between Mr. Friedman and your grandchild Harlan?
Yes.
All right. And how do you go about supervising those?
But I give her privacy on the call and have them recorded, and I review them afterwards so that she feels like she can talk freely.
Okay. And as far as you understand, are both Harlan and Mr. Friedman and the guardian ad litem aware that these calls have been recorded?
Yes.
Okay.
Did she say I passed?
She said, yeah. Or
And
yeah,
if you're,
I think.
all right, actually, I'll just pull these up really quick. So due to the time constraints, and actually, I don't really know how you want me to share it. I have some audio files that are uploaded to Box. And I was just going to refer to them by exhibit number. But Ms. Jenkins, you've reviewed the exhibits that we have today. The Zoom audio files, it's P37, P39, P41, P43, P45, P47, P49, P51, P53, P55, P57, P59, P61. Have you reviewed those audio files from the Zoom conversations between Mr. Friedman and Harlan?
Yes.
And you were the one that took those, that recorded those audio files?
Yes.
Okay. And they are true and accurate to the best of your knowledge?
Yes.
Okay. I'll seek to admit let's see. So basically it's the odd numbers exhibits between P37 and P61.
Yes.
Any objections?
I don't know what they are. What are we admitting?
I've shared them with you. I've shared them with Mr. Friedman, so he had an
He
opportunity.
identified them as audio recordings.
Yes, Your Honor.
Well, if they're audio recordings, I haven't heard them, but if they're recordings of conversations that we had, I can't speak to the authenticity of them. So I guess I would have to object since I don't know what they are.
Overruled.
And you also turned those audio recordings into transcripts to make it easier to attach to the motion to enforce. Is that correct, Ms. Jenkins?
Yes.
Okay, and those are represented in petitioner's proposed exhibits 36 to 60 as the even numbered exhibits, correct?
Yes.
And those transcripts, those are true and accurate copies of the audio recordings to the best of your knowledge.
Yes.
Okay, and I move to admit P36 to 60, the even numbered transcripts.
Any legal objection, Mr. Friedman?
Again, I don't know the authenticity of them.
Okay, I will overrule. They're admitted.
Your Honor. And Ms. Jenkins, Generally speaking, from those admitted exhibits, what are your primary concerns about the behavior of Mr. Friedman that's represented in those exhibits?
He continually tells her that things are not just, they're not right, they're crooked, and he gives her false information about what's going on, and he shouldn't be talking to her about it at all. He's tried to get a phone number from her several times.
Okay. Has he ever made threats about what he wanted to do to you in front of Harlan?
Oh, he told her, I'm going to jail.
Does he often tell her that she is going to be returned home in a pretty expedient fashion?
Pretty much every phone call.
And how does he refer to you, to Harlan, about you or living with you?
That it's not her real home, that she's not being well cared for.
Does does he typically refer to you and the other you and Justin and Susie and the other Jenkins as bad people?
Yes.
And how does he refer to the court system?
Crooked.
And do you get any do you have any opinions on how, on why he's telling Harlan these type of things about the litigation?
To impress upon her his view of things.
And what do you understand his view of things is?
That this whole thing should never have happened, that it's completely absurd. And he's kind of expressed his feelings already, and I would concur.
Mm-hmm. Yeah, was it more than one occasion that he's asked Harlan to provide her phone number?
Yes, yes.
And are there any other concerns you have about the calls with Mr. Friedman that we didn't already go over that come to mind? I know that's kind of open-ended.
She'll just, if it's a real stressful call, if he really criticizes her about not paying attention or not looking at the camera, she gets aggravated and annoyed with it, and she doesn't say much, but she'll get a headache, and then sometimes that leads to an upset stomach.
Okay. And have you ever heard Mr. Friedman like raise his voice or get frustrated with Harlan while on the phone?
Yes.
Okay. Can you describe that situation?
Well, he is very frustrated with the whole situation, and if she's not looking at him directly or not, if she, she's 10, she might look off to the side and look at me. I'm your father. You need to speak to me properly. That sort of thing. Pay attention to me when I'm talking to you. Don't look away. Look into the camera. Don't,
Mm-hmm. And per the temporary orders, Mr. Friedman is restricted from having any other contact with Harlan other than supervised Zoom contact and supervised visits, correct?
Yes.
All right, so we're gonna go to P5.
Excuse me, Your Honor. Will I have a chance to examine Ms. Jenkins? Because as you say, we're getting very low on time here.
Yes, Ms. Kleinhans, you need to wrap up with
No.
this witness, and the court is going to want to hear from the guardian.
Yes, Your Honor. All right, I'm just gonna share P5 really, really quick. All right, and is P5 your proposed disposition of the issues for this case today?
P5?
Oh, I'm sorry, didn't share. Is this what you're asking the court to award today, but for the support that we stated earlier, we were not going to go forward with today?
Yes.
Okay, then I move to admit petitioner's exhibit 5.
Any objection to 5?
No, Your Honor.
5 submitted.
Okay, and on this,
However, I have not read it. I have not had an attorney read it. And so while I don't object to it being admitted, I don't concur with any of the content, and I could not possibly do so without an attorney.
Understood. Go ahead, Ms. Kleinhans.
and Ms. Jenkins, you're asking the court to make the findings as shown on page 8, starting at 25.
Could you go
Through,
Okay. Sorry.
yeah, through the reliefs at 41. Is that correct?
It bounced back up to 40. Did you want me 41 or 40 or 41?
41. So 25 to 41 is what you're asking
Oh,
the
I'm
court.
sorry.
The findings you're asking the court to make.
Yes, please.
Okay. Under the relief requested, you are seeking that basically this gets given that we're holding off on the finances, are you asking that the court just hold off on any attorney fee award on the enforcements until that hearing? Okay, I'll strike that question. I'll just address that later. And then going down to 43 at 6, you're asking for a set date that Dr. Thorne commence a psychological forensic exam on Mr. Friedman.
Yes.
Okay. And then number 8, that Mr. Friedman be ordered to sign the release for the Chase bank account 8158.
Yes.
And number 9, that you're asking for Mr. Friedman to be ordered to sign the releases for Dr. Wartenberg, his primary care physician, and for Dr. Thorne, correct?
Yes.
All right. And then number 10, so that we can be best prepared to enforce all the financial obligations, are you asking the court to make the orders to produce documents as is typical in enforcement hearings when basically there's a resistant respondent such as Mr. Friedman?
Yes.
Okay. And finally, you're asking that the court find that the protective order has been violated. That's the protective order that ran April 27th to 2022, or April 27th, 2022 to April 27th, 2024. You're asking that the court reinstate that because during the duration of the protective order, Mr. Friedman violated the several provisions, but primarily the provisions concerning the forensic evaluation and the communications with the child.
Yes.
And I'll pass the witness, Your Honor.
Ms.
All right,
Jenkins.
Mr. Freeman.
Do you recall filing charges? I think there were 11 sets of charges in Carroll County about violating this protective order?
Objection, non-responsive. Or I'm sorry, objection, outside the scope of evidence.
Right, Mr. Freeman, your questions need to pertain to the enforcement, okay?
Okay.
That's what we're here on.
They do. They're relevant.
Ask a new question.
Do you why did you did you consider the use of talking parents, which is the court-ordered software, which your attorney requested me to purchase, and which I did, and you filed, I believe, 11 sets of charges saying that you found the court-ordered software, my use of it, to be harassing. And those resulted in, I believe, 3 months of no communications whatsoever with Harlan, because under the faith and credit, while the judge in Maryland was extraordinarily aggrieved at the issue, she said she had no choice but to enforce the protective order. And technically, since there was an error and one of the orders specified talking parents and the other didn't, so I guess technically that was in violation. Why did you believe that that was in Harlan's best interest to cut off all communications for 3 months? And why did you believe using the court-ordered software was harassing?
Objection, and that was argumentative and a narrative statement as part of the question, and it's confusing and duplicative.
Okay, I think it was a compound question. Mr. Freeman, will you break it down
Surely.
one question at a time?
Surely. Why did you find the use of the court-ordered talking parent software that you requested me to use for communication harassing?
Because the court ordered that we switch to Our Family Wizard.
And you are aware that Our Family Wizard has no means of communicating via voice. And the court did not order that. There was Our Family Wizard was specified in one order and talking parents was specified in the other. But are you aware that Our Family Wizard has no means of talking? They may have just added it, but it did not until recently.
Objection, compound question.
Mr. Freeman, will you break it down?
Are you aware of the fact that at the time you filed charges, there was no way to use Our Family Wizard to speak?
To speak to me,
Speak to Harlan.
it was about speaking to me, not to Harlan.
No, you said that you found, I could produce the document, but we don't have time. The charges, and like I said, I believe there were 11 sets of them in Carroll County, said specifically that you found the use of talking parents. You said that you found Our Family Wizard because I asked you about the possessions of Heidi's that disappeared via Our Family Wizard, and then was informed that that wasn't appropriate use, and so I didn't use it for that anymore. But in terms of talking to Harlan, talking parents was the only option. So why did you find that harassing?
You were harassing me, not Harlan. The comments were directed to me, not to Harlan.
If we don't have time, I'd be happy, Your Honor, to produce that document and send it after we conclude these proceedings, where Ms. Jenkins says that she finds the use of talking parents to be harassing.
Okay, it is not going to aid the court in deciding this enforcement. That is all I'm here to do today.
Okay,
So if you have questions of this witness that go to the enforcement, ask them. If you don't,
question for this, sure. So in the course of the approximately 300 talking parents, first off, I will have to add, can I call myself as a witness and then come back to Deborah?
y'all are both about out of time. So, and the court is going to hear from the guardian before we are done here today.
Okay, and are you
You've already put yourself on one time, Mr. Friedman, so.
all right? Are you aware that your filing of charges for using talking parents to speak to Harlan, not to speak to you, that is what the documents contain, and I believe there were 11 sets. Are you aware that resulted in 3 months of no communications between Harlan and I? And can you tell me why you found that harassing? Me using that software to speak to her harassing?
I don't recall the events as you're stating them.
Fair enough. And are you aware that your attorney asked me to use that software and I via email to subscribe to that software to use to speak to Harlan?
Objection, facts outside the evidence.
What's your response, Mr. Friedman, to the objection?
I could produce the email, but again, we don't have the time.
All right, again, this whole talking parents is not relevant to any of
Well,
the
I believe it
enforcement issues.
may I explain the relevancy?
I'm telling you, it's not relevant, okay?
When you said bad people, what there was no reference to you or anyone else. It was a general reference. So what makes you think that I was calling you bad people? And well, that's the first question. I have a follow-up question.
Because you did.
No. In any case, my second question is, over the 300 or so conversations that we've had via this extended period of time, you've made these broad, sweeping generalizations, and unfortunately, we don't have time to go through these things. How many times do you think over those 300 conversations that these instances, which I do not necessarily concur with at all, how many times do you think that happened?
The court specified it wasn't to happen at all.
But you made sweeping generalizations as if it happened many times. So I'm just
I've
saying,
answered your question.
no, you have not. I asked you for a number.
You weren't supposed to at all.
Objection, Your Honor, non-responsive.
Overruled.
Of course. Well, then I would ask why you felt it was in Harlan's best interest to cut off all of our communications for 3 months.
It wasn't.
Objection, facts. Yeah,
I'm sorry, what was the objection?
just facts outside evidence, but
I'll sustain.
I have no further questions.
Okay. Anything else, Ms. Kleinhans, for this witness?
yeah, I'll pass the witness.
Okay. You may put yourself back on mute. Are we ready to hear from the guardian, or is there anything
Yes.
else?
Yes, Your Honor, and I just have a couple of questions. I mean, like I said before, I was just planning on going forward with mostly financial, so not a lot I have for her at this time.
Okay, that's fine. Well, I mean, I guess if you don't think we need to call her, given the issues that you're pursuing, let me know.
I mean, I would like to for the calls. I know she's reviewed some calls, so.
Okay.
And I would like to call her as well.
Okay, Ms. Fox. You swear or affirm the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth.
I do.
Okay, go ahead, Ms. Kleinhans.
Thank you. And Ms. Fox, do you believe that the forensic exam of Mr. Friedman and the mental health records of Mr. Friedman, if there are any additional ones from his primary care physician, Do you believe those would be helpful in your final report to the court?
Yes, they could be.
All right. Do you have concerns about Mr. Friedman complying with obtaining that forensic exam?
Yes, and that it's been an extended period of time, and to my knowledge, there's been no appointments for that exam.
Okay. Are you aware the last time that Mr. Friedman had a supervised visit with Harlan?
I believe it was in February of last year of 24.
Have you reviewed the Zoom calls between Harlan and Mr. Friedman?
I've reviewed some, not all, but I've reviewed some.
Do you have any concerns about the way that Mr. Friedman communicates with Harlan?
Yes, and I've reminded him on multiple occasions to not speak with Harlan about the litigation, not to refer to her mother in derogatory language, not to tell her that her grandmother is going to go to jail, and to focus on Harlan's current activities and what she's doing with school and other things that are going on in her life.
Do you have concerns about the way that Mr. Friedman portrays what's going on in the litigation to Harlan?
Yes.
All right. And how do you see him portray that?
He constantly, in the calls that I've seen, talks about corruption, talks about things being done wrong, that he's trying to correct mistakes, talks about her returning back home to him in Austin. Those are the kind of the primary things.
And how have you seen Mr. Friedman respond to you when you've talked to him about refraining from talking about the litigation, calling the Jenkins names, and the other examples you gave?
There's either no real response or the response is about his feelings about the litigation and that it's a misjustice for him to be in this situation and he doesn't have anything else that he can talk with his daughter about in order to maintain that relationship. So I think those are the kind of the primary ways. I honestly haven't addressed that with him in the recent past because none of my prior recommendations around that have been followed.
All right. And do you feel like when you talk to him about that, he wants to make an honest effort to change that going forward?
I don't know. And I had asked actually when he did parent coaching with Dr. Summer Allen's office where they provided the curriculum of the protective parenting, I had asked that issue around how to talk to Harlan in these calls be addressed so that he would be able to find more productive and positive ways to engage with her in those calls to try to help resolve that issue to some extent.
All right. Do you know if that was ever addressed?
My understanding from Dr. Allen was that yes, they did cover that topic.
Okay. Do you know if that, well, and since you've reviewed the calls since he completed that parenting class, have you seen really any of that same behavior change, like that he really stopped calling the Jenkins names and all the other examples?
No.
All right. I pass the witness.
Okay. Mr. Friedman, go ahead. You're on mute, Mr. Friedman.
How many calls have you reviewed, Ms. Fox?
I don't know. I would have to look at how many I have. I've saved the ones I think that I've reviewed.
Like 5 or 10, and are they generally?
It's probably at least 20 to 30, I would think.
And when you review them, do you review them at Ms. Jenkins' request?
Initially, she sent me a link that I think had all of them at that up to that point in time. That's been quite some time ago, so I don't know when that was. Since then, she will periodically send me ones when she has, I think, significant concern about what was being said.
Okay. And so of the 300 calls, it sounds like there's about 20 that we have an issue with. My next question is not about calls, but it's about visitation. You had recommended that we move to unsupervised visitation, and of course that would be in concert with the public policy of the Texas Family Code that tries to ensure that the relationship of the child and the parent is maintained. And so I would like to know if you're ready to prepare. I filed a motion today to follow your recommendation to move to unsupervised visitation. I believe that was made about 3 or 4 months ago.
I don't recall when I made the recommendation. However, I did put that recommendation out. My understanding was Ms. Jenkins is not in agreement with my recommendation.
And but you agree that unsupervised visitation would be an appropriate thing at this point.
Objection, relevancy.
I'll overrule the objection. You may answer.
I am trying to look at ways to move forward, and I think moving to unsupervised visits, while I have concerns about the topics of conversation that Harlan would be exposed to, I do think that with some sandwich visits and monitoring of how unsupervised time happens could happen safely.
Thank you. Do we have an opportunity to make a statement before we wrap up? About 2 minutes?
We might have an opportunity for brief closings.
If I pass Ms. Fox as the witness right now, will we have that time?
Yes, I
And
think
I
so.
will-
Anything else, Ms. Kleinhans? For this witness?
Just one other real quick question.
Well, I'm sorry. I didn't say I was passing. I have one more question for the witness. Would have had several others, but I'm going to keep it short.
Okay, one more.
And do you believe that this severing of our relationship because of the distance and because of the interruptions in communication, because of the charges that were filed and things, do you believe that that's healthy for Harlan?
I believe Harlan having consistent communication and consistent visits with her parent is important.
And do you believe that it would be useful for her to be able to visit outside here back in Texas, which was her home, with, of course, appropriate safeguards such as giving up my passport and stuff?
I'm not prepared to make a recommendation for a change in the visit location at this time.
I passed the witness.
Ms. Kleinhans?
Thank you. Do you believe it would be in the child's best interest for Mr. Friedman to have unsupervised visits prior to having his forensic psychological exam?
I made that recommendation without him having that because I don't know that is going to happen. So as I said, was looking for ways to try to move the family forward with having some more normal kind of visits and contact, despite some concerns that I have with the communication that he has with Harlan.
And do you feel like you need to have unsupervised visits occur before you can complete your report to the court, regardless of the circumstances?
I don't believe it would have to. I mean, I think if it was moving in that direction, then the feedback from those visits could be helpful. But I can be prepared for report at any point if it now.
Okay. Would you have concerns that Mr. Friedman would flee with the child, given that he's still found to be a flight risk?
I understand that that's the finding that the court made. I have not seen or heard anything from Mr. Friedman that gives me reason to believe that there's anything else that would cause him to be a flight risk, other than the finding of the court and then his extreme frustration with the litigation.
Yeah. And do you have any concerns based off listening to the recordings of things that he's stated to Harlan that would potentially raise red flags that he could be a continued flight risk?
Not that I can recall offhand.
All right.
All right, Ms. Kleinhans, you need to wrap up.
All right. All right. Okay, I'll pass the witness.
All right, anything else, Mr. Friedman?
Not for Ms. Fox, no.
Okay. Are we ready to give brief closings on the motion? Anything else, counsel?
Not for me, Your Honor.
Okay. All right, looks like y'all both have 2 minutes. Go ahead.
All right. Yeah, we're just asking for the relief that we set forth in the end of Ms. Jenkins' testimony, as set forth on the proposed issues. The attorney fees be confirmed and the interest be confirmed. That's set forth in there. That was also included in the order. That a set date for the forensic exam be ordered. And those bank statements, the releases for those in the medical records so that we can move forward with this litigation and the production related to the finances of Mr. Friedman, so that when we get to the enforcement hearing, we can be prepared to show exactly where that can come from and not have to be guessing. And then we are also seeking reinstatement of the protective order based off of the violations of the previous protective order. And leave. Oh, and finally, that the attorney fees, that we could just reserve that issue on this hearing and combine it with the attorney fee issue for the enforcement, specifically the enforcement issues to be heard at the enforcement of the support case. So thank you, Your Honor.
Okay, Mr. Friedman.
Okay, first off, regarding the reinstatement of the protective order, I think that would be an absolute travesty. There's no grounds for that. Ms. Jenkins has made some general assertions about my communications with Harlan. I have no insight whatsoever into her communications with Harlan. I have no insight into what she's even been told about her mother's death. I have no insight into anything. And so I'm at a complete disadvantage here. And you're well aware that I believe that this entire proceeding is a travesty, but here we are today. The one thing that we should not be doing is taking a step backwards, because ultimately this is my daughter and I was her primary caregiver. And as her principal said, who saw her last, there was never any indication of a problem. Her own therapist talked to her the night before Heidi absconded with her. There was never any indication of a problem. CPS talked to her after Heidi absconded with her. There was never any indication of a problem. Ms. Fox has testified that she has no concerns either about unsupervised visitation, and she testified in the past that she had no concerns about any abuse to Harlan. And that in and of itself, I don't believe there's grounds for it, and I believe it would be in complete violation of the public policy that ensures to promote the integrity of the family. There has been so much damage here that it is impossible to describe. And while you have consistently ruled against me in every aspect, I am asking you, because I do believe you are a parent. This was my child. This was my life. And she was taken from me. Her mother died. I have not been able to have an unsupervised visit with her. I haven't been able to discuss her mother's death. The fallacious protective orders prevented me. I was in Maryland waiting to get Heidi's body prettied up so Harlan could say goodbye, and the protective order prevented me along with Miss Jenkins. And I will say, for whatever reason, you have not listened to me or Heidi speaking from the grave about the extraordinary malice that Miss Jenkins has demonstrated prior to this event. And I will note that Heidi died in her home. And I will note that I said I was concerned for all of our safety in our first appearance. My first appearance in front of you, I said to you, we are all in danger. I never expected something this grave could happen. And I also told you that one of the reasons that we were in danger was because Heidi had been abusing some drugs and because she had PTSD in the presence of her family. And so restoring our communications and giving us our life back, I believe, should be the primary concern of this court, rather than going and trying to just continue to drive a wedge between my daughter and I, and to continue to financially devastate her future and her sister's future. And I would also add, by the way, I asked for her phone number for her sister. Her sister would like to maintain communications with her. And her sister, because of her work schedule, can rarely, if ever, get on Zoom calls. And that is why I asked for her phone number. So, Your Honor, what I would ask you to do today, despite your consistent rulings against me, to think of my child and to think about our relationship and to consider the fact that I was her primary caregiver, and to consider the fact that everything I have done has been not only to protect her and in her best interests, but in Heidi's best interests as well. I asked for a protective order knowing full well that the state, my mental state my wife was in since going off of her lithium, she was completely erratic, and that is why she got arrested. And I was trying, and we've never gone through that, because all the therapists that were originally on the witness list didn't want to testify against me because they knew I was trying to help my wife. And I would ask you, rather than move us backwards and continue to inflict harm on me and ultimately onto Harlan, to stop that harm today and start helping us move forward from what has been, what people consistently tell me is the single worst thing that they could ever imagine, worse than being sentenced to death. And I concur with that. Thank you.
Okay. All right, a couple of things. So,
Excuse me, Your Honor, if I may add one more thing. I did file a motion this morning, I know it's late, to modify visitation per Sharon's recommendations. That's all.
okay, so motions have to be set for a hearing. They have to be announced per the local rules. So you will need to accomplish that if you wish to get a hearing on that, okay? So a couple of things. I want to make sure that going forward, Ms. Kleinhans, it sounds like you intend to have the contempt piece or that heard at some future date and time.
Yes, Your Honor.
Okay. So I want to make sure everybody in the courtroom understands that if there is a motion seeking jail time, that Mr. Friedman would either have an attorney of his own choosing with him at that hearing. And if he is claiming indigency, he will need to file the appropriate paperwork and have it submitted so that it could be heard on that date and time, on some date and time. So, because of constitutional concerns, we haven't heard any contempt claim that would result in jail time today. But if you plan on doing that in the future, I need to be sure that everybody is on the same page. Okay, any questions, counsel or Mr. Freeman?
No, Your Honor.
Okay. All right, and Mr. Freeman, there is paperwork on the district court's website indigency paperwork. There is also the law library you can consult with. But that's not in front of me today. So, Ms. Kleinhans, as far as what we heard today, I am going to ask that you put together an order that sets out the relief your client is seeking. And I'm going to study that and compare it with the actual testimony and evidence brought forth, the exhibits submitted at this hearing, and I will study it and I will rule on each of those items.
All right.
And as far as the attorney's fees, that can be carried forward or urged at the contempt hearing in the future. Any question?
Thank you, Your Honor. This drafted order, do you want me to have it reviewed by Mr. Friedman before I send it over, or just copy him on the email sent to the court?
You can copy him on the email as you would with all communications to the court. It doesn't need to be approved as to form because this isn't a final order. I just want to see, because your 15-page motion is now quite different and shorter. I want to see an order based on what you're seeking.
Understood, Your Honor. Thank you.
Okay.
Your Honor?
And the other issue, you had requested a contempt finding for the behavior in Mr. Freeman's repeated refusal to answer questions. That is also carried forward. And I think you volunteered briefing on that, but I don't need that at that most important. But
Okay.
Mr. Freeman, if there is jail time, you need to have an attorney. Do you understand that?
I do.
Okay.
I do have a question for you.
Okay.
Can we set a hearing date on visitation? I filed a motion today.
You will need to go through the regular process of doing that. Did your attorney explain that to you before he withdrew or not?
He did not.
Okay. We have local rules in Travis County. You have to confer with Ms. Kleinhans about a date and a time that would be good. And then since it's set with me, you will need to contact Ms. Seeger, my court executive assistant. So 2 things: confer per the local rules about when it can be set and heard, but then you do have to go through Ms. Seeger because she has my calendar, not the court administrator. Okay.
Yes, thank you.
Makes sense.
Yep.
So y'all are welcome to confer about that and then get back with us. But that is all I have for you. So appreciate the guardian being here. And be sure to keep her copied on any future hearings that you are scheduling, counsel and Mr. Freeman. Okay. Thank you.
Thank you, Your Honor.
All right. Everybody is excused and free to go. Have a
Thank
nice
you, Your Honor.
weekend. Take care.
Great, you too. Thank you.